Over here.
Okay, Paul Johnson, I'll try to be quick. I guess I'll direct it to Professor Strauss, but the whole panel can weigh in if necessary. You mentioned in your talk that conservatives like predictability and something that you can, stability. I think conservatives and others like freedom more. And for example, conservatives and others like be free to own property, but are offended by the Kelo ruling that says you can take property for public purpose rather than use. And conservatives and others like not having their race held against them and are offended by Plessy and Grutter. So I'm wondering, are you concerned that respect for precedent will have the courts in society sort of affirm decisions that are, I think by most people's, well, by society's standards being unconstitutional?
Well, the question we're really focusing on is what is the role of the courts? And a case like Kelo or a case like Grutter did not foreclose freedom, what you would think of, I take it as freedom protecting actions. You and I might disagree about that, but even I'll grant your point for purposes of argument. It just said, you know, if you think what the New London City Council did in Kelo was unconscionable, your remedy lies with the New London City Council. If you think the University of Michigan is pursuing a terrible practices because they have a pernicious influence on the university or on society, take it up with the authorities in Michigan. That's really what we're talking about. And as to that, I think that it is not only legitimate, but sometimes really necessary for a court to say, look, I think, and judges on both sides will do this, you know, look, I think this is a terrible law, but I just don't see any way to strike it down. I think actually, you know, we talk about judges being politicized and judges reading their political views into the Constitution. I think, you know, all the time, without even our noticing it, judges refrain from doing that. There is, you know, you can have liberal judges who think that the Bush tax cuts were absolutely terrible policy. They're never in a million years declared unconstitutional. You could have conservative judges who think that, for example, the regulation of the environment is terrible policy, who would say, no, I can't strike that down. We settled that years ago in the New Deal. So I think that would be my answer to you, that the arguments you make, this is a question of to what forum do you direct that argument, those arguments, and why the courts are sometimes not the appropriate one.
Okay, last question over here.
Chris Rosina from Penn.
Oh, I'm sorry. Go ahead.
Sorry.
Yeah. I agree that conservatives like liberty, to use your quote. However, I think the great question of the next generation will be whether or not conservatives like liberty more than they like representative self-government. I think if you read the law reviews of the land and you read the statements of progressive constitutionalists and you look at the things that they're going to be putting in play over the next generation, you can see that the great debate is going to focus on whether or not the role of the judiciary should be enhanced in American life or whether or not the processes of Republican self-government should be enhanced. And this is a common theme in all the great issues that are now percolating. We're talking about whether or not the privileges or immunities clause of the 14th Amendment is going to be reinvigorated and slaughterhouse reversed, whether the civil rights cases are going to be reversed of the post-Civil War era, whether the 9th Amendment will be identified as containing a plethora of hitherto unidentified rights. All these things in the end will end up strengthening the role of the courts and diminishing the role of the people acting through their representative processes. But I think all these things, too, will tempt many conservatives who like liberty. Because in each of these areas, there are many conservatives, and this is reflected right now in the Second Amendment case that's pending before the United States Supreme Court. There are some conservatives who will succumb to the temptation to try to find the right judge who will identify their favorite kind of liberty at the expense of the traditional role of the judiciary in American society. So yes, conservatives do like liberty, but that will not be the great issue of the next generation, finding judges who will live up to that standard, but it will be finding judges who live up to the standard of maintaining the kind of architecture of constitutional government that we've known in this country for several centuries. As
tempting as it is to stop on that crescendo, I did promise the last question over here. Go ahead.
I'm Chris Rosina from Penn. Professor Strauss, you mentioned that in the future we're probably going to see some liberal originalists that want to try to use this to overturn it. Now, implicit in that is the assumption that there's different original interpretations, or that a true originalist could come to different understandings. But you also started your talk talking about how there are times that, people did disagree, that the original understanding was a disagreement and a compromise. Using those two ideas, if someone is a true originalist and they really are going to stay faithful for that, does it really matter if they're liberal or conservative? Because even in the situations where there was a divergence of view and there was a compromise, they meant to compromise, and they meant to come in from that. So wouldn't a true originalist come to the same conclusion whether or not they were liberal or conservative? And then do we really need to be afraid of these big bad liberal originalists that are going to come around and start overturning things that they don't necessarily like?
Yeah, I'm not sure they're big or bad, or that they'll come around for that matter. Chris, I think a true originalist, I think, when confronted with, often when confronted with the historical evidence, would find him or herself saying, there really was no original understanding about this. I mean, there were various things said in the debates, but they kind of, one side said one thing, the other side said the other. They never resolved it. They went ahead and adopted that provision, or this kind of issue never came up, or gee, they didn't really debate it very much. They just kind of adopted it. I don't know what they thought about this particular issue. And then I think even in circumstances, I said in my opening remarks, even in circumstances where there was an original understanding, the originalists would be troubled by the question, well, okay, am I entitled to update this? Am I entitled to say, well, circumstances have changed and we now have things they didn't anticipate, so now what? Do I say that, do I sort of extrapolate their purposes, which is what Justice Scalia suggested? Well, gee whiz, start extrapolating their purposes, and then the big bad liberal originalists can go to town. Because what was their purpose? To create a just society. That was their purpose, and then you're off to the races. So I think someone who really was trying to get the history right would very often find him or herself just stuck, not irrespective of views, not really able to resolve the case.
Well, with apologies to you and to the panel members to whom I so rudely interrupted, I do want to say thank you very much for your attention and for your very stimulating questions here at the end, and I thank our panelists very much.
To be continued.